breaking news coming in here. The hearing in the Rafale review petitions have resumed in the Supreme Court. And Justice K.M. Joseph has asked the Attorney General and has observed that the RTI has overriding effects of the Official Secrets Act. My colleague Meenakshi Banja joins me from the Supreme Court with more details. Meenakshi, this entire argument seems to center on the Official Secrets Act versus the right to information, and which one takes precedence when it comes to disclosing information of national importance?
Well, that's right, Aarti. These are very crucial set of arguments which are presently underway. Remember, 14th of March was earlier determined as the day when the arguments would have continued in the Supreme Court. Yesterday, we saw the affidavit which was brought on record and submitted by the MOD, which is seeking for the Supreme Court to dismiss these batch of review petitions. And very, very interestingly, when the matter commenced at around 3:10 in the afternoon today, we have seen the Attorney General again being pushed on the back foot on this one. And this has happened because the line of questioning adopted by the Supreme Court again seems to have trumped the Attorney General, which is why these observations go on to assume a lot of importance. And like you referred to, Honorable Justice K.M. Joseph of the three-judge bench is making the observation to the Attorney General as to how the RTI Act has overriding impact on the Official Secrets Act. So much so that Section 24 of the RTI Act has been quoted by the Supreme Court bench, which goes on to enumerate as to how even intelligence and security establishments are bound to give information about corruption and human rights violations. Subsequent to that, the attorney has also been handed over a circular by Justice Joseph, which is the Office of Memorandum, prepared by the DOPT, which categorically states that file notings are covered under Section 24 of the RTI Act. Now, the attorney was seeking exemption of these secretive materials invoking the RTI Act, and clearly the bench at this point in time seems very unimpressed with that line of argument. As we speak, Prashant Bhushan has resumed his counter. He is also going on to highlight as to how the government's reason for seeking privilege in this case is malified. Documents, according to Prashant Bhushan, are already out in the public domain in public interest, and he is also citing a case law of S.P. Gupta judgment to highlight as to how the law in India is well settled about public interest preceding over privilege.
Right, Meenakshi, and just for the benefit of our viewers, now there's a certain background to this case, because the last time the Attorney General had claimed that certain crucial documents were stolen, and there was quite a bit of controversy over that statement.
Well, that's right. That's a statement which even official sources in the attorney's office did concede later, that the word stolen was a very heavy word to have used and could have been perhaps avoided. But the fact of the matter is, we also saw a U-turn coming in from the attorney after having taken a position of the documents being stolen for nearly over 2 hours in the last hearing before the Supreme Court pertaining to the Rafale review hearings. 24 hours later, the attorney communicated as to how there was a misinterpretation. He was merely referring to the documents being accessed in an unauthorized way and being photocopied and produced in Supreme Court. So clearly that is again one line of argument which the Supreme Court for now does not seem very impressed by.
Right, Meenakshi Banja bringing us all those updates. We, of course, will keep coming back to you as a Rafale review hearing is underway in the Supreme Court. Thanks so much, Meenakshi, for joining us and putting that in perspective.